Hello everyone, and welcome to our fifth and final LP research workshop. My name is Professor Ashley Arrington, and I will be walking you through our workshop today, which will be focused on verifying your research. However, we will first do a brief review of all that we've covered this semester, including our four-step research process and our methods for locating relevant codified and case law. I am not going to read these learning objectives out. However, I just want to point them out so that you can come back to them for your own review purposes and to check in with yourself and ask yourself whether these are indeed the things you are taking away from today's workshop. So, as you'll recall, our four-step research process is what we've focused on throughout the entirety of our workshops throughout the semester. So, in our first four workshops, we looked at steps 1, 2, 3, and 4, respectively. So, if you'll recall, our step 1 process is our issue analysis, where we are working through our who, what, when, where, why, and asking ourselves, what is the legal issue, right? Who are the legal parties involved? What is the relationship between those parties? What jurisdiction are we in? What do we need to know to answer this question or issue of law? What do we already know about that area or issue? Just walking through that process that helps prepare us for the next steps of our research. So from that issue analysis, we've hopefully pulled some keywords or key phrases that we might use to seek out relevant secondary sources. So that's our next step, right? Step 2, we're looking to secondary sources for a couple of reasons. The first of which is to get that background contextual understanding. So maybe you haven't identified the relevant keywords or phrases until you get to secondary sources, and that's okay too. Looking through that background, contextual information that you're finding in your secondary sources can help you to determine what the relevant keywords or phrases are that you can use in your later searches. The other reason we use secondary sources is for time and efficiency purposes, right? So we're looking to secondary sources first as they point us to relevant codified law and case law, rather than just jumping into a database, throwing a bunch of keywords or phrases in, and then hoping we come up with relevant results, right? Save yourself time, save yourself money, and save yourself some clicks, because as we know, these databases are costly and will charge by the click depending on what subscription your firm provides. Okay, so sort of reflecting on that four-step research process that we've been focused on this semester, I want to pose the question, why and how does the four-step process help us research more effectively? Okay, so we kind of talked through this already, right? Starting with our issue analysis helps us to narrow the focus. Then going to secondary sources gives us that background information and guidance with respect to where we're going, right? Searching for codified law first ensures that we find the relevant statutes, relevant regulations, whatever form of codified law it is. Of course, we focused on statutes during our step 3 discussion and our workshop 3. So we do that before we turn to case law research within step 4, right? And then we can see how those statutes have been interpreted, right? So that's the reasoning for looking to codified law prior to looking to case law. So this is a more systematic approach, right? We said it saves time, reduces guesswork, and helps us to ensure that we have gone at our research from a more comprehensive review, right? So You know that you've walked through each of these respective steps so that you can feel good in knowing that you've looked everywhere you need to look, and know that you've completed all of the relevant steps. This is not to say that you won't move through that process multiple times over, right? We've talked about how you may need to work through those steps multiple times in order to gain more information throughout your research process. So within our last couple of workshops, we focused on our research methods for both codified law and case law. So as you'll recall, we'll look at codified law first. As you'll recall, codified law encompasses more than just statutes, right? We focused on statutes for our research purposes during that workshop. However, codified law can also include regulations, constitutions, local court rules, right? Not just statutes. But we did look at 5 different methods for seeking out relevant statutes. So the first one was known citation, right? We have that citation, someone has given it to us, or perhaps we found that relevant citation within a helpful secondary source. But that is generally not going to be the case that we will be handed the precise citation, right? So oftentimes you will browse the table of contents to look through that statutory structure and framework in order to see how this area of law is laid out within the statutory framework. That can cost you some time, right? So browsing is not necessarily the most efficient way, but sometimes it may be helpful if you really have no idea where to start, you don't have any keywords or phrases that you know to look for. You can browse through the table of contents, at least find the relevant area of law, and then go from there. Our next method is using the index, right? We talked about Westlaw having more indexing tools than Lexis. And if you'll think back to using our index, right, we can start from any relevant word, right? So our example during our workshop was oil and gas leases. And so we saw that we could start with oil, right? We could go to oil or O within the index to look for oil. We could have started with G for gas. We could have started with L for leases, right? It doesn't matter where we started. We would ultimately get to the relevant statutory code section because the index is designed to help us get there. We also talked about the popular names table. One example is Obamacare, right? So let's say you do not know that the official title for that statutory code is the Patient Protection and Affordable Care Act. You only know the word Obamacare, so you could go to O and look for Obamacare and get there that way. You know the short version, Affordable Care Act. You could go to A, Affordable Care Act, and get there that way. Or you simply know ACA. You could go to ACA and get there that way as well. Right, so that's another method that we can use. And then finally, advanced searching. We're going to talk more about advanced searching in the spring semester. So we'll talk more about using our Boolean terms and connectors that we're not quite as familiar with just yet. And so that is a large part of why we focused on these other finding methods first. You will become more familiar with these terms and connectors within each database, and understanding how these queries are processed by each database. But again, we'll talk more about that in the spring semester. And now, at this point, as new researchers, your first inclination should not be to jump into a keyword search on that top search bar, right? We want to use these finding tools that are valuable and can help us get where we're going in a more efficient way. In our last workshop, we looked to case law research. So we saw that, just like with codified law, with case law, we have a number of methods that we can use to get to the relevant case law that we need, whether that is mandatory or persuasive. So again, our first option was known citation. So someone's given that to you, you found it in a secondary source. As we said, you're not likely to be handed a citation frequently within the practice of law. Party name, right? So you have a party's name, that's all you know, you don't have the citation. We looked at searching with the party name in order to find the relevant case. Then we talked about our one good case method. So we talked about finding one relevant case and using that single case to get to so many so many additional relevant sources in case law, right? So we have one good case. We have all of these beautiful tools that our wonderful attorney editors have put together for us, right? So we looked at headnotes, we looked at key numbers, and we'll call back to that in just a moment. Citing references, table of authorities, right? We had all of these wonderful methods that would be beneficial for us working from just one single case. And then finally, advanced searching, and same cautions here, right? So you're not yet familiar with how to best build these queries or what these queries, how these queries are read by these respective databases. So we're going to focus on that more so in the spring, but again, that is one other research method that you will become more familiar with as time goes on. Now, we'll recall the importance of determining whether the case law we're looking to is mandatory or persuasive, right? So, with respect to secondary sources, those will never be mandatory, right? Secondary sources are always persuasive. However, primary sources can be mandatory, right? We have to look at a few things. Outside of case law, codified law within our jurisdiction will be considered mandatory. And then with respect to case law, opinions that are coming from a higher court within our jurisdiction or from the court itself, that precise court will be considered mandatory, right? Whereas persuasive authority would be coming from a lower court, right, or the court of another jurisdiction. So, for example, we have a decision in the Texas Court of Appeals, Dallas District, that would not be binding on the Texas Court of Appeals in Houston, right, because they are separate jurisdictions. However, it could be considered persuasive authority. We've spent a lot of time talking about citators, right? We talked about that last time. We'll continue to build on that today. But essentially, as we've said, a citator is an index of legal materials, right? These attorney editors have done the work of taking all of this legal information and categorizing it, indexing it, so that you have tools to get where you're going in a more efficient way. So it tells us two things, right? It tells us when our authority was cited, right? So citing references, on Lexis it would be citing decisions or other citing sources, right? And then we also see how our authority, the source that we're looking at, has been treated. We're going to talk more about that today. But so we're seeing two things here, right? We've got quantitative information, how frequently are we seeing this, and then qualitative. So how is it being used, right? Is it being treated in a positive way, in a negative way? And then as we'll see, we'll build on that and get even more specific in terms of the type of treatment received. So, right, two reasons, right? We've talked more so about using citators to find authorities, right? Whether that be codified law, case law, or secondary sources that may be helpful to us. And then today we're going to talk more so, or continue to build on that second purpose of seeking to verify the law that we are wanting to use in our legal work product. So regardless of whether we're using case law or codified law, we want to make sure that what we're using remains good law, and we can use citators to do that as well. So first, let's briefly review that first reason that we're using these citators, right? So again, we looked at this more closely during our last workshop, but we saw that we can use citators to find other relevant authorities, right? Whether cases, statutes, secondary sources, whatever it is, that can help you further your research. So again, keep talking about these wonderful tools that our attorney editors, both on Westlaw and Lexis, have put together for us. And you can see a number of these tools here, right? So we're looking at the DC versus Heller case here, and we can see our top search bar, or not search bar, but that top line, right? We have a number of different tabs. We've got our negative treatment tab, so we can see the cases that have negatively referenced the case we're looking at, DC versus Heller. History is going to look at all of what's happened, all of the subsequent history, so we know what's going on prior to looking at this case. And we see our citing references. As we've talked about, our citing references are sources. It could be case law, it could be codified law, it could be secondary sources, all types of sources that are citing our source here, which is DC versus Heller. Cited with would point us to cases that are cited alongside our case here. And then table of authorities are the sources that are relied on, that are cited by this authority, by DC versus Heller here. And then we've also talked about headnotes and our topic and key numbers as additional tools, right? So the headnotes are those summarizations of a point of law, of a point of case law, right? Headnotes are specific to case law and not codified law. So they are a tool we can use to further our case law research, and then they fall within a certain topic. Or on Westlaw, we've got the key numbering system, so that's another way we could search, right? Again, that is specific to Westlaw. But we've got the headnotes and the topics that are useful on both Westlaw and Lexis. So just looking at this, all of these arrows, and then also we just talked about additional tools beyond the headnotes, right? Topics, key numbers. We have a whole host of tools that can be helpful to us in furthering our research. And so that's what we mean by we take one good case to get to so many other relevant sources. Once again, reiterating the value of finding one good case, right? We can see some of the things here, working from one good case to get to other good cases by way of headnotes, right? By way of the table of authorities, by way of key numbers, case history, right? A number of those tabs we just looked at. So hopefully you are seeing the value of just that single source that you can work from in so many different ways. So this should be review as well. So again, we talked about our topic and key numbers on Westlaw, and then our headnotes on both platforms, right? So all of these are, again, indexing systems where the attorney editors have done the work for us of taking these points of law and organizing them in a way that we can use to further our research. So they're reading these points of law, summarizing them, And then with respect to Westlaw, they're assigning both a topic and a key number. With respect to Lexis, they are assigning a relevant topic area. Remember that headnotes are not part of the case, right? They sit above the case. They are there as research tools, and you should not cite to those headnotes. But you can and should use them as a research tool. So our next focus, and that second reason for using a citator, is to verify the law, right? And we don't want to use citators for one purpose or the other. We want to use citators for both purposes, as they are both hugely important. All right, so let's talk about using a citator to verify the law. Again, we looked at this last time. We pointed you to some of the flags and signals that you can look to determine whether your case is still good law. So on the right here, we see KeyCite, right? That is the name of our citator on Westlaw. If we're looking at a case and we click on Powered by KeyCite, which is at top right, this image at right here will come up and show us these respective meanings for the different flags. As you'll note, these flags can have different meanings depending on whether you're looking at cases or statutes, right? Case law or codified law. On the left, we see the meanings for what Lexis calls their signal indicators. So if you are looking at a case, you can shepherdize that case, and we'll talk about a number of ways you can get there here in just a moment. But you go to your Shepard's report, and then you'll have to scroll down a little bit to click on Legend, and that's where you will find the meaning of these respective signal indicators. So, with respect to verifying the law, right, we looked at a number of these tools for getting to other relevant sources, right? We just looked at that previous slide with all of those different arrows. Now we're narrowing in to those resources that are going to help us verify the law. So if we were to click into negative treatment, that tab will list only those citing cases that have negatively referenced the case that we're looking at. So in this instance, it would be those cases that have negatively referenced our Tennessee Valley Authority versus Hill, right? If we look at history, again, that explains the evolution of this case by linking us to both previous and subsequent opinions. But both of these can be helpful to us in verifying the law. Also, when you click on negative treatment, and we'll come back to this, but clicking on negative treatment is taking you to what you will call a KeyCite report. And we'll see that with Shepard's as well, how to get to their report as well. So now you can see those same two tools. We're looking at Lexis, same case, right? We see our history tab at top. So we see our previous and subsequent legal proceedings related to Tennessee Valley Authority versus Hill. And then at right, you see this box that says Shepardized Document. Now, if we were to click there, it would take us to our Citing Decision tab at top left. So you could also, if you look at right here, you could click Citing Decisions here, right? So there are a number of ways for you to get to what is called the Shepard's report. You could click here, you could click here, or you could click here, right? So you can get there in a number of different ways. But again, we're seeing negative treatment here, and we're seeing the history, which are both tools that will help us to verify the law on which we are seeking to rely. Now, it is not as simple as caution or positive treatment, neutral treatment, cited by, right? You can see these are just a couple of examples at right here. You can start to see caution could mean distinguished by or criticized by. Neutral could mean a whole host of things. We're starting to see a list here, right? They're not all listed because the database is only telling us the ways that our case has been treated, right? So let's look at a example of what some of these could mean. So this is an example from Lexis, right? So as you can see with these examples at top, Lexis has given us a caution signal indicator, but it could mean that the case was criticized, but reluctantly followed, as stated in this other case. It could be criticized but reluctantly followed by in a different way. Criticized, it could be criticized. Neutral treatment could be criticized by questionable precedent, or criticized by questionable precedent at a specific source. And let me just point out that this is a 110-page document, right? So each of these phrases, again, you would get there by way of that initial indicator, right? Whether it's a caution or positive treatment or neutral, right? You can see this list goes on and on and on. We're on page 60. Now we're on page 70. Right? So you take the point that it is not as simple as simply looking at the yellow or blue or green signal and understanding how the case was treated. Hopefully that serves to highlight that this is much more complicated than just simply looking at that signal. Okay, so this highlights that this verification process, your duty as an attorney to use these tools as a starting point and then work through that analytical process of understanding how they apply and in what ways specifically the type of treatment played out, is the type of analysis that you're engaged in as a lawyer, right? So again, these citators, they're flagging issues for you, but you must analyze them to determine the sources that are relevant for your research purposes, okay? We talked about how citators help you analyze when and how authorities have been cited in later cases or documents, right? Quantitative and qualitative information. We also talked about how they help you to analyze the validity and relevance of sources, the significance of factors such as jurisdiction or date or the reasoning provided, or point us to and help us to analyze additional relevant sources. Again, they point us to potential issues, but we as lawyers must analyze these issues to understand how or if they apply to us, right? And once again, this goes beyond positive, negative, neutral, etc. We just looked at that lengthy document with 110 pages of different types of treatment that caution or neutral or positive could encompass, right? So do not simply look at the flag or symbol and rule out a source, right? You need to dig deeper. What does that particular symbol or flag relate to? What point of law, right? You have to dig further in order to determine that and to determine whether you can use it for your research purposes. We've noted that citators should be used for multiple purposes, right? Not just as a finding tool, but for this verification of the law that we are seeking to use, right? And again, we've said multiple times, don't depend solely on the flags or symbols. You need to read the authority to see if that negative treatment applies to the point of law that you are concerned with. Let's take a look at our demonstration and in-class exercise. So I'm going to use one case that we'll look at both on Westlaw and Lexis so we can start to see some of the differences in how these citator systems and reports are laid out on the two different platforms. So I'm going to take this Tennessee Valley Authority that we just looked at briefly, right? Some of this we've already looked at. We talked about our history tab and our negative treatment tab. Again, if we click on our negative treatment tab, this is what will be referred to as the KeyCite report. If we want to find the meanings of those flags, again, top right corner here, powered by KeyCite, and then we can see the meanings of these respective flags so that you can start to develop an understanding of what those mean when you initially look at a case, right? Going back to our report here, you can also see at right, well, actually, let me point at left first. We see a more specific treatment, right? Just like we did in that long list for Lexis. And then if we look at right, we can see the depth of treatment and then relevant head notes. So the head notes are going to signal those summarizations that are referenced in this particular case, whereas the depth of treatment is going to reference how extensively our case that we're looking at, the Tennessee case here, was discussed within this citing case, right? And again, this list is those cases that have cited our case and given our case some form of negative treatment. If you look to and find this green quotation, you can see I've hovered over it and it's highlighting that this case quoted our case, right? And then it points us to where that happened. So that is what the green quotation signals. Then we see flags here, right? We have a flag to the left of our case, right? So we can see some negative treatment with respect to our case. Then we also see some negative treatment with respect to the citing cases that we're looking at. So we've got these cases have cited our case, right? We know that our case has received some negative treatment, but because of these flags, we also know that these cases citing our case have received some negative treatment. So as you can see, if I hover over those flags, Westlaw will tell me this flag applies to this case right here, right? So just remember that you can hover over, that is a helpful tool. And then I want to go to the top of our document. You can see that Westlaw has marked this case, Maine Lobstermen's Association, as being the most negative case. So of all of these citing cases that have negatively referenced our case, Tennessee Valley Authority, in some way, our Westlaw attorney editors have determined that this Maine Lobstermen's Association is the most significant, right? And so in terms of those cases negatively treating our case that we're looking at now, they have said, okay, this Maine Lobstermen's Association case is the most significant, right? And we'll look at that on Lex's as well. Okay, so here we are on Lex's, right? I'm going to use the same case. So we're just going to enter our citation here. Okay, so this is what we looked at on our screen previously, right? We can see, we talked about how there are multiple ways of getting to what is called a Shepard's report, right? You could click on citing decisions. You could click on citing decisions here. You could also click on Shepardized document here, right? We talked about how the history tab and our Shepard's report, our citing decisions tab, is helpful for our verification processes. Then you can see different types of treatment, right? So these are decisions from various jurisdictions that have cited our case. If you want to look at only those cases that are positive, that have treated our case more positively, you can click there. Same thing with warning or caution, right? You can move into whatever type of treatment you want to focus on. As we saw with Westlaw, you can also look to the depth of discussion. So we've got just one bar here, just one. We've got some more extensive discussion here with Strahan. And I'm going to move to the left here so that you can see that you can also narrow by the level of discussion, right? So you could look for only those cases that have most heavily analyzed the case, our case, right? Tennessee Valley Authority. You can narrow in that way as well. Okay, how do we get to our signal indicators? So we're going to go back to our case here. And then we are going to go to Shepardize. Again, we could do that from our top citing decisions tab, from our right link, or Shepardize document. They're all going to take us to the same place. And then, as we said, you'll need to scroll down a little bit to click on the legend. And then the legend will reveal what those signal indicators on Lex's mean. Okay. Now, we talked about on Westlaw, right, the indicators to the left of our case, right? So you can hover over, you see that Tennessee Valley Authority has some negative treatment, right? And then we saw on Westlaw, we saw flags to the left of the cases that were citing our case, right? On Lex's, it is a little bit different, right? So that signal is to the right of the case within that list, right? So just a small difference, right? For both platforms, we see a signal to the left of the case we're looking at. And then in terms of those cases that are listed, on Westlaw, we saw that signal relative to the citing case on the left, and then on Lex's, it is found on the right. Okay. Now, I also want to go back to our main page. To show you that at right, we see our signal, right? We've already seen that at the left of our case. We already know that there is some negative treatment indicated. If we click on Y here, we can see a description from Lex's as to what they feel, what their attorney editors feel is the most relevant case that has negatively treated our case, right? Remember that Westlaw, we saw Maine Lobstermen's Association. Now we're looking at Lex's, and we see Hoosier Environmental Council. So you can see our text up here says the following reference has been editorially selected, right, by those attorney editors as having the strongest influence on the overall Shepard's signal indicator. So this is we're looking at a negative signal indicator, right? We've got our red stop sign here. Again, that's not to say that it applies to the case wholly, but that you must investigate to determine how it applies and if that's relevant for your research purposes. But then again, Lexis is telling us that this case is more significant in the way that it negatively referenced Tennessee Valley Authority. So this should highlight the differences between these determinations, right? You may or may not agree with this determination. You may agree that, not Hoosier, but Maine Lobstermen's Association was more significant in terms of that negative treatment. So, just an FYI, right, these are tools that can help you. These are not determinations that you should rely on. These, again, are developed by attorney editors. They may be considering different factors when they're looking at these, so they may be prioritizing specific legal principles or broader policy considerations, right? So you've got to critically evaluate both of these databases in order to make your own determination as to your ultimate findings and how it will impact your own research. Let us next look to our in-class exercise. You may recall during a previous workshop we used Westlaw to look for the statutory grounds for divorce in a number of jurisdictions. I think we looked at Texas, Florida, and Hawaii. So now we're on Lexis. We're going to do the same thing. Our question asks us to locate a secondary source that will help us to find the grounds for divorce in Texas. So we could narrow into content and go secondary materials and then narrow into jurisdiction, Texas, right? So we'll do that in just a moment. You could narrow by the type of secondary source you're looking for. You could also narrow by a specific publisher, but since we're not yet familiar with those, we'll move into Texas. Starting from that main page, you also could have done Texas first and then secondary sources, right? We'll look at all secondary sources here. We've got our list of those top secondary sources. Dorsonio's Texas Litigation Guide is a big one in Texas, and you'll see a list of those other texture, right? That's our Texas Legal Encyclopedia. So let's go, we can search across all of these secondary materials. I'm going to search grounds for divorce, and again, we're looking at secondary sources specific to Texas, right? We see a couple of results that will be relevant to us. So Texas Family Law Practice and Procedure points us to the grounds for divorce. Dorsonio's Texas Litigation Guide, the Texas Jurisprudence, right? So I'm going to click on one of these. I'll choose Dorsonio's Texas Litigation Guide. And our next question is asking us, working from this source, what is the citation to the statutory code section specific to divorce based on grounds of living apart? The easiest way for me to do this is probably just Command F. And so that's what I'm doing here. I did Command F, living apart. So it takes us to that part of the discussion. And the question says, what is the statutory code section that's relevant? We see if the spouses have lived apart without cohabiting or resuming marital relations for at least 3 years. A divorce may be decreed in favor of either spouse. And then here we see our statutory code section. So our relevant section here is the Texas Family Code, section 6.006. Okay, so now I'm going to click there so we can move to question 3. We're going to work from this code section to find a case that describes the meaning of cohabitation, okay? So I'm going to just do Command F once again, and I'll do cohabitation and see what I can find here. So our first mention of cohabitation is within our notes to decisions. So we talked about those this semester. You'll recall that a note of decision is similar to a head note, and that it is also a summarization of a point of law from a case. But it is different from a head note in that the case is specifically speaking to an interpretation of codified law. So here we are at the Texas Family Code, section 6.006. So our notes to decisions are going to include summarizations of points of law from various cases, but these cases and summarizations are meant to help us interpret the statutory code section here, which would be 6.006, right? So only reasonable meaning of cohabitation is the term includes living with another, whether married or not. And then we see Kurtz v. Jackson, then we see our case citation. So we did Command F, right? That's one approach. In this example, we found it within notes to decisions. That is called notes of decisions on Westlaw. Same concept though. So now I'm going to click into this case so we can move to question 4. And the question asks us, is this good law, right? So we see our signal in a couple of places. We see our signal here to the left of Kurtz v. Jackson, which shows that positive treatment is indicated. And then we can also look to the right? We see our positive signal here. If we were to click Y, the Lex's attorney editors would tell us we think that Shields is most significant, right, with respect to that positive treatment. To get to our report, our Shepard's report, again, we could click Shepardized document, we could click citing decisions here, we could click citing decisions up here. So I'm going to click there again. And then we can see that our case, Kurtz v. Jackson, has received, it's been cited by a number of cases, and it's received positive treatment, right? We don't see negative, we don't see neutral, cautionary, right? So let's click on positive. So because of that positive signal, right, we know the case has not been overruled. Again, it's only received positive treatment or been cited by other cases. And then our case, if you look to the left here, you would also see this if you were to click on the case itself. We are working within the Court of Appeals in First District Court, which is in Houston. The Houston falls within the 1st and 14th Court of Appeals. But however, our question tells us that we're within a Fort Worth family court. So again, they're both in Texas, right? But we're looking at different jurisdictions with respect to the level of intermediate appellate court, right? Here, this case is coming from the Court of Appeals in Houston, the First District, whereas we would want to look for a court of appeals within Fort Worth, right? So this can be persuasive, right? But it's not going to be mandatory or binding for our purposes. And then we clicked on our positive treatment, right? And we see a case that's listed, Shields v. Delta Lake Irrigation, and that has been specified. It's positively treating our case, right? But it is it followed our case, Kurtz v. Jackson, right? So it says what case followed ours, Shields v. Data Lake Irrigation, right? And then we also see the head note 3, right? So it says use the head note assigned to identify the relevant topic of law. If you hover over head note 3, you can see our topic of law is contract interpretation, ambiguities, and contra proferentum. Okay, so Shields is our case, and then our topic is contract interpretation, etc. That is all I've got for today. In the spring, we will continue to build on what we've talked about this semester, our 4-step research process. We'll do a refresher at the beginning of the spring semester, and then look at advanced searching, right? Talking about using our Boolean terms and connectors, and starting to dig into how best to build those queries. Then for step 3, right, codified law, we've talked primarily about statutes. We're going to build on that by talking about regulatory research and legislative history research. And then we'll also do a couple of sessions with a more practical focus. So looking at some of these practice-focused databases where we can find relevant legal forms. And then our last session, we'll talk about using generative AI for legal research, which of course is a new thing and very exciting and impactful for both legal research and the practice of law. So if you have any questions, there are a number of ways to reach out. As always, please feel free to reach out. We are happy to chat and answer your questions about this lecture, the in-class exercise, the final assessment. So once again, please don't hesitate to reach out. Thanks so much for your time and attention today. Bye-bye.